Hello students. Today we'll proceed further with the topic of contract of agency. Now today's first topic is position of an agent. Although we have discussed about the rights and duties of the agent already in the previous lectures, now we will discuss about the liability of the agent towards the third parties. We already have discussed that it is the principal who will be liable to third parties for the acts done by the agent. But there are certain situations wherein the agent will be made liable personally on his acts and not the principal. So, which are these situations? This will be covered under this topic. So, first of all, agent generally cannot be made liable personally for the lawful acts that he is doing on behalf of principal. Then he also cannot be asked to specifically perform the contract because it is not his liability, it is that of the principal. Thirdly, he also cannot personally enforce the contract entered into by him against the third parties. So he is not in the picture. The liability between the principal and third parties towards each other, agent has no such role in between. But there are certain exceptions where the agent will be liable personally. Before that, let me also discuss with you this case I have mentioned here. Board of Trustee of Port of Madras versus Southern Shipping Corporation. In this case, a consignor who was a principal, he appointed a consignee, that is an agent, that some consignment was to be sent through a ship, and consignee was asked to take delivery of the goods from that ship. But he failed to take delivery and there was delay, and because of that, the ship owner, he charged a penalty or a fine which is called demurrage. He charged the demurrage for the same. So in this case, the liability of paying this fine was falling on the principal and not on the agent. So agent will not be liable, but the consignor or the principal will be liable for the same because of the rule which we just discussed. So this rule is established under section 230, which says the agent is neither liable personally nor he can personally enforce the contract against the third parties. But we have some exceptions to this rule. That means we have certain circumstances wherein the agent will be liable personally. So those exceptions are, first, when the agent is acting for a foreign principal. Now your principal is residing abroad. In case a third party wants to take an action against the foreign principal, they cannot take because principal is not living here, staying here. So in that case, agent will be accountable, agent will be liable personally. But agent can exclude his liability by initially showing to the third party that he should not be made liable personally. So if he has clarified something of this sort in the beginning, then he may escape liability. Otherwise, he will be liable for acts done on behalf of a principal who is a foreign principal. Second is when the agent is acting for an undisclosed principal. This we have discussed already, that in case the principal is an undisclosed principal, then that principal will never be liable, but liability will be falling on the agent only. Third case is where the agent is acting for a principal who cannot be sued, who is an incompetent person. So in that case, the liability will be falling again on agent because an incompetent person cannot be made liable. Then when agent is acting for a non-existing principal. So if there was no principal existing, that means you have done something on behalf of a principal which was not in existence at that time when you did something. So with this regard, we'll take the example of promoters of a company. So the promoters of the company, in order to float or incorporate the company, they enter into so many transactions before the company is incorporated. So in that case, because company is not in existence at that time when all these pre-incorporation contracts were done, so company cannot be held liable for the same. So promoters, being the agent of the company, will be liable. So in this case also agent become liable, and with this regard we already have discussed this case Kellner versus Baxter in the previous topics. Fifth case is where the authority of the agent is coupled with interest. Agency coupled with interest means, in some cases, agent also has some personal interest in the contract of agency, in the transactions that he is entering into with regard to his agency contract. Like, for example, there was a business where he was doing something on behalf of principal, but he also has invested some of his own money. So in that case, he also has some interest of his own. Besides being an agent, he also has some interest in that agency business. So in such cases, because he also has his own interest, not only interest of an agent, but also in his independent capacity. So in that case also, he will be liable personally to the extent of his interest involved. Like, for example, there's a business in which rupees 10 lakh has been invested, out of which 7 lakh was invested by the principal and 3 lakh was invested by the agent. So agent's interest is 30%. So to the extent of 30% liability falling on the principal, agent will be liable to the extent of 30% only. Then in case agent has received some money or he has paid money by mistake or under any misrepresentation or fraud, he will be accountable himself for such mistakes and not the principal. Personal liability by agreement. In some exceptional circumstances, like that of del creditor agent, which we discussed in the last lecture, that del creditor agent will be liable personally for the bad debts, etc. Because in that case, he already was being given some additional remuneration to bear such losses. So he has to bear the loss of bad debts. So he is personally liable for making good the loss of bad debts to the principal. Eighth is, sometimes in certain businesses, there are some customary practices, there are some trade practices which hold the agent liable personally for the acts done under the agency contract. Ninth, where the agent exceeds his authority. Now, in case agent done some jobs beyond his authority, which he was not authorized to do, so obviously principal will never undertake any liability on that in case he has not ratified those acts. So accountability will be that of agent again in such cases as well. Pretended agent, in case there was no principal, agent only falsely represented before the third party that so and so person is my principal. So he was only pretending to be agent of a person who was never your principal. So in that case, the agent will be liable personally because there's no principal as such in this regard. 11th is where the agent has formed the contract in his own name. Although he is agent, although he has a principal, but while entering into a transaction, he used his name in his personal capacity. He never indicated that he is working on behalf of somebody else. So in that case, the liability will also fall on the agent because he has made the contract in his own name and not in the name of the principal. Like in this case, Alliance Mills versus India Cements Limited, the agent purchased certain goods in his own name and he signed the documents also in his own name, and he never indicated anywhere in the documents that there is some principal also. So in such a situation, the agent could personally be made liable also, and agent could personally take action against the third parties as well. So these are the topics of position of agent or personal liability of the agent. So in between this topic, we also have discussed this short topic of agency coupled with interest. Now we are left with the last but very important topic of this chapter, sub-agent and substituted agent. So when we discuss the kinds of agent, there was a classification of agent and sub-agent. And I described that we are going to discuss this later on. So this is a topic now. Sub-agent and substituted agent. There are two types of agents here. So let me discuss first of all the substituted agent. Now a substituted agent, with the name, it appears that he is a person who has been appointed in place of the agent. He is a replacement of the agent. But legally speaking, it is not like that. Substituted agent is an agent who was named by the agent, who was proposed by the agent to the principal, because the principal has approached you and he has sought your help to name any person to do something for the principal. Now, with the knowledge and consent of the principal, agent found out a person and he handed over the name of that person to the principal. Now, this named person is not going to act in place of agent. Agent will be working as such as before, but this person is a new person whom principal wanted for some other task. So this will be said to be substituted agent. So as per the name, the meaning is not the similar one. So in this regard, what is the duty of the agent? Agent's duty is that he should find out a proper person, a right person for the said job with a very reasonable care, and he should use his discretion and should be very careful in selecting a right person. And thereafter, it is all the job of the principal and the substitute agent, and agent's liability will cease here. But in case the agent was careless in finding out the right person for that job, then he will be made liable for losses caused to the principal because of this negligence. Maybe the right person was not chosen and the substituted agent made some mistakes and the principal has to suffer some losses. Then these losses will have to be compensated by the agent because it was his carelessness which caused this situation. But having said this, agent in this case does not give any guarantee for the solvency, skill or integrity of the person selected. He selected a right person. That person was fit for the job. He was having the right skills for the job. But later on that person did some mistakes. So agent will not be answerable for such wrong things or mistakes done later on. So let me give you one example of a substitute agent. There was a solicitor. He was approached by a person, his client, and now he's an agent of that client. But the client said, I need an auctioneer to auction my property. And this agent said, okay, I'll find out somebody for you who will be working for you as an auctioneer. Now he found out a person named Ruplal. Ruplal was suggested by the agent and Panalal, and this person was appointed. So in this case, this person Ruplal is not working in place of Panalal. He is also not working under Panalal, the agent, but he is a substituted agent, and he will be liable personally to the principal. So in this case, the liability of the principal of the substitute agent is directly towards the principal. So let me add it here. The substituted agent will be accountable to the principal and not to the agent. The second topic is sub-agent. Now, who's a sub-agent? Sub-agent means when an agent appoints a person as his agent to work under the agent. So this sub-agent has also been defined under section 191, which says a sub-agent means a person employed by and acting under the control of the original agent. So an original agent has appointed a person to work under him, under his control, and to perform or to help him in the business of agency. So now agent was supposed to do this task for the principal, and to do this task, agent appointed his sub-agent. So it is only between the agent and sub-agent, principal has not come into the picture. And we can say that relationship between the agent and sub-agent is similar to the relationship between the principal and agent. That means for the sub-agent, agent is the principal, and for the agent, sub-agent is his agent. Then, so in that respect, agent will have the similar duties and liabilities that were with the principal. Now, sub-agent has to work under the control of the agent. He is not working under the control of the principal, and he is not bound by the principal also is not bound by the acts of sub-agent, because there is no contractual relationship between sub-agent and principal, because sub-agency contract is between agent and sub-agent only. And further, this sub-agency contract will continue till the agency contract continues. So in case the agency contract is discontinued, sub-agency contract will also automatically get terminated. Now, appointment of sub-agent. Is it allowed to the agent to appoint a sub-agent? What are the rules regarding the same? So the normal rule says that agent cannot delegate his powers or duties to any other person without the express authority or consent of the principal. Because of the rule, delegators non-protest delegate. So a delegate cannot further delegate. You yourself have got delegated authority. So authority was given to you. So this authority was not your power. It was given to you by the principal. And something which was given to you by somebody, how can you pass that on to somebody else when this authority was not belonging to you? So because authority given to agent is personal, so he cannot use this authority through any other person, which is sub-agent. The reason is the contract of agency is a fiduciary contract, which is based on confidence and trust on a person. Now the principal has selected a specific person as an agent because he thought that this agent has the requisite skill and he is a trustworthy person for the job which I am entrusting to him. And in that case, agent, instead of doing that job himself, passes on that job to somebody else. That means in this case, you are not following the confidence and trust posed into you by the principal. So section 190 says in this regard, agent cannot lawfully appoint a sub-agent to perform all the acts which he was asked by the principal to perform personally. So principal has asked you to do that job. You have to do those jobs personally. And you cannot get those jobs done through somebody else. This somebody else here is the sub-agent. But there are some exceptions to the rule of section 190, means there are some situations where agent can be allowed to appoint a sub-agent. So those are, first, in case the ordinary customs of trade allow the appointment of sub-agent. Second, where the nature of agency is like that you are needing, you need to appoint a sub-agent. Like for example, a builder was given the job to get a building built up, and to complete that building project, he also appointed an architect to do the architectural rules. So in this case, the nature of agency was such that the building contractor, he has to undertake the services of the architect. So in this case, the architect becomes the sub-agent, and the nature of job was like this, that you were requiring to have a sub-agent. Third is where the act to be done through the sub-agent is purely ministerial. Ministerial means something of clerical nature, like you are doing sale of goods on behalf of principal, and to maintain the accounts and to pay all the GST thing and all, you needed an accountant or a lawyer. So in that case, clerical nature of jobs, for clerical nature of jobs, you have appointed an accountant or a lawyer. Fourthly, where the agent was expressly given this authority that he can appoint the sub-agent, then of course, principal's consent is with you, so you can go ahead and appoint a sub-agent. Fifth, where unforeseen emergencies require that you should appoint a sub-agent. Now suddenly the agent has fallen ill, or he's got fracture. So in that case, he cannot complete the task of agency himself, and he needed somebody's help. So he appointed a sub-agent. So it was a right situation. Lastly, where principal is already aware that agent wanted to appoint a sub-agent, and knowing this fact, principal never showed any objection on that. So in that case, if agent appoints a sub-agent, principal cannot later on say refuse for this appointment. So these are the situations where a sub-agent is allowed exceptionally. Now, what becomes the relationship between these three parties, the principal, the agent, and the sub-agent? So in this case, we have two subheadings. Section 192 and Section 193 describe this relationship. First is where sub-agent is properly appointed. Properly appointed means he was given permission, due permission by the principal for the same, or the circumstances they allowed you to appoint a sub-agent. The circumstances that we just discussed above, the exceptions. So, if the appointment of sub-agent was allowed either by the principal or by the exceptions that we just discussed, then the relationship will be this way. So, relationship says because sub-agent is properly appointed, so principal will be liable to the third parties not only for the acts of agent but also for the acts of sub-agent. So, liability of principal becomes twofold. Secondly, for the acts of sub-agent, accountability towards the principal will be that of agent because agent appointed the sub-agent, so agent is accountable for his acts to his principal. Thirdly, sub-agent is accountable only towards the agent and not towards the principal because contractual relationship is between agent and sub-agent. Principal has no direct link with the sub-agent. But in case the sub-agent commits any fraud or willful negligence, then he also becomes liable towards the answerable or liable towards the principal. Second case is where sub-agent's appointment is improper or where he is appointed without authority, without express or implied authority, then the relationship will be of this sort. First, now, agent will be acting as a principal for the sub-agent. So, for the acts of sub-agent, agent will be accountable to the principal and also he will be accountable to the third parties. So, agent's liability for the acts of sub-agent becomes twofold towards the principal and also towards the third parties. Second, principal is not being represented by sub-agent here because sub-agent is representing only agent and his appointment was not authorized by the principal. So in that case, principal will not at all be liable for the acts of sub-agent. He only will be liable for the acts of his agent. Then, sub-agent has no accountability towards the principal at all. Even for the willful negligence or fraud, or he will not be answerable to the principal. He will be answerable only to the agent. So when this question comes, generally, they do ask the difference between sub-agent and substituted agent as well. And even if they don't ask, to complete the answer, you must add this portion as well. So differences will be, so again, as I have explained you earlier also in the class, the differences must be given in a tabular form with the proper basis of difference and this way table form. So first difference is meaning we have done, section we have done, example we have done some examples, you can add those. Now, other differences are works under whom. Sub-agent works under the control of the original agent. And substituted agent, he works under the control of principal. He was named by the agent, but he's working under the control of principal only. Second is privity of contract. Privity of contract means contractual relationship. Sub-agent's relationship, contractual relationship is with the agent only. He has no direct contractual relationship with the principal. So because of that, he is not answerable to the principal directly, except in case of fraud, etc. In case of substitute agent, there is a contractual relationship between the substitute agent and the principal. So both can take legal action against each other directly. Third is, what is the original agent's responsibility? Now, original agent will be responsible for the acts or for the negligence of the sub-agent towards the principal. And the original agent, in case of the substitute agent, original agent is not responsible for the acts of the substitute agent. His responsibility ends once he names a proper or a right person for the job of the substitute agent. Let me add here, this liability is towards the principal. And lastly, what is the liability of these two agents towards the third party? Now, towards the third party, in case of sub-agent, principal will be liable if sub-agent was properly appointed. That means if the sub-agent was appointed with the due authority or permission of the principal, then principal becomes liable towards third parties. But in case his appointment was improper or it was not allowed by the principal, then agent becomes liable towards the third party for the acts of this sub-agent. But in case of substitute agent, the liability of the working done by this person will always be falling on the principal, and agent can never be made answerable for the acts of the substituted agent. So with this, we end with this topic of sub-agent and substituted agent, and we also come to an end with the topic of contract of agency. And this also winds up the Indian Contract Act 1872. Thank you.